What was supposed to be a routine court hearing quickly turned into a tense legal standoff when a defendant accused of serious domestic violence and child abuse stood at the center of a growing controversy. The real shock, however, wasn't just the charges, it was the revelation that he never turned himself in, despite a direct order from the judge to do so. His attorney insists it was all a misunderstanding, claiming he believed his client only needed to appear in court, not surrender to custody. But prosecutors strongly disagree, pointing to the defendant's troubling history and the alleged victim's fear, saying the situation is far more serious than the defense suggests. As arguments heat up, questions about missing evidence, disputed phone records, and multiple ongoing cases only add fuel to the fire. Inside the courtroom, the judge's frustration becomes impossible to ignore. He openly questions the attorney's judgment and warns that ignoring a court order could be a sanctionable offense. The atmosphere grows increasingly tense as the court weighs whether this was an honest mistake, or a calculated attempt to delay justice. With the defendant's freedom on the line and the attorney's conduct under scrutiny, the judge delivers a decisive ruling that changes the course of the case and leaves everyone wondering what consequences may come next. Stay tuned as we break down every moment of this dramatic courtroom clash and what it could mean moving forward.
We're going to deal with the bond hearing first and then decide if we're going to go with this case. Mr. Vincent.
Well, Your Honor, is the witness here? Because that is all. I mean, all the allegations are based on her words. There's been no police contact, no video, no third-party witness, no DNA, no fingerprints, no police contact with my defendant here.
So he wants a hearing on this bond violation?
None of these phone numbers connect to his account. He absolutely denies the allegations in here. There is no physical evidence, and if there is not a witness here, Your Honor, then both the underlying case should be dismissed and this alleged—
I'm not even talking about the underlying case. So just deal with what I told you to deal with.
All right, well,
does he want a hearing on the bond violation?
Absolutely, Your Honor.
When are you going to have the other report?
I'm not sure, but I can check on that today. I'm also waiting for the actual screenshots of the text messages that are written in the Romulus police report. And if he's saying that that's not his phone number, I can also get a search warrant as to that effect.
In that police report, there are 6 phone numbers listed. The police report indicates that none of those numbers are Mr. Carter's. If there are screenshots, I have not received those screenshots. It's the first time I'm hearing that there are 2 other potential police reports out there. However, this police report says that 2 officers showed up. I don't know how a Wayne County Sheriff's Department police report would be any different than this, as far as I can see, there were no Wayne County sheriffs on the scene of this alleged incident. There's just simply no physical evidence. There's no third-party evidence. And frankly, if you read through the report—
I did. Before I revoked your client's bond.
Yeah, okay, well, I would hope you did. When you start to read through it, the allegations in there, either it's a lie or he's the luckiest guy on the planet, because I would think that the Romulus PD would be able to get over there in the length of time that all of this stuff is alleged to have happened and find a purple Taurus. She says at 1 p.m. He began to call her, and it somehow got into an apartment, beat on the door of the apartment, left the apartment, started yelling through the window, and generated somehow, all while outside, 6 other phone calls from 6 different numbers, none of which line up to the defendant. If she's not here, Your Honor, then I think that is a very, very strong indication that this is not factual. The other thing in this, Your Honor, this person alleges that he stole a gun from her in Pittsfield Township. Yeah. Well, you know, if that's the case, then shouldn't this have been a little higher priority? I think the prosecution knows that this is not accurate. There's just simply, there's nothing before the court today to indicate that he is guilty of what they're saying he's guilty of. If she's not here, she should have been here. There's no Romulus police officers here, not that they saw anything anyway. There's no third party in the police report that says witnesses, none. Wait a minute, he's broke into this apartment complex, banging on the door, goes outside, supposedly shouting the N-word. Don't you think somebody would have witnessed that, especially at 2 p.m.? Without a witness, without some shred of physical evidence, there's nothing. This is just the allegations of someone who did not bother, apparently, to show up to court, both for this and presumably for the underlying charge.
First thing, this defendant is on bond awaiting this final settlement conference where he's charged with domestic violence. He's also on bond awaiting pretrial where he's charged with child abuse fourth. He's also on bond waiting a probable cause conference where he's charged with resisting and obstructing a police officer and fleeing third degree. Mr. Vincent claims that he knew nothing about screenshots. Well, I just said on the record I don't have them. I'm awaiting them. But they are in the Romulus police report. They say that they do have screenshots, so maybe he didn't read that report. Also,
oh, Your Honor, I don't have screenshots.
You will not interrupt, ever. I let you go on and on. I told you what I'm trying to focus on here. Keep trying it, Mr. Vincent. You're going to run into trouble with me real fast. Ms. Kirby, you may continue.
Thank you. I also explained in my motion that the Romulus police report is different than the two other contacts that this victim had with the sheriff's department. I have included those police numbers. Those are also in the motion. So I'm not sure what he means on, I have no idea why the sheriff's department and Romulus were here. No, it's completely different. And I don't have the accusations in those. I'm awaiting to get those, given that they're not in our county, and I followed the process to get those. Also, this is, if we're having a bond violation hearing, I would just remind the defense counsel that it's not beyond a reasonable doubt for a bond violation. So I would ask the court to take what it has in front of it, including the Romulus PD report, and either adjourn so I can get the other police reports, and so I can get the actual screenshots and possibly a search warrant for this. And I would ask for the defendant's bond to be revoked and he to be remanded. Given the seriousness of this case and the seriousness of his other two cases, I do believe he's not only a threat to the victim, but to the safety of the community and also children. He seems to find it funny as his defense attorney speaks, which also tells me that he does not take this as serious at all, which also concerns me. As for the complaining witness not being present, I did not know that he was going to be here. I thought he was still out since he had not turned himself in, and his attorney was well aware that he had a warrant out with no bond. So she is not present. Last time I spoke to her, she was in fear for her life. She said she would continue to answer the phone, but she has been placed in a different place that I know of the location that she does not want me to share out loud. I have no problem sharing that with the court, but she is not present. And regardless if she was present or not, I can still proceed based on forfeiture by wrongdoing with the interference that the defendant has committed himself through these other police reports. And I was going to ask for time to get those anyway so that I could present those at trial. So regardless if she is here or not, and just for the record, the court rule does not actually say I have to have a witness present. It actually says I have to say if I can proceed or not, which is what I'm doing. Thank you.
Anything else, Mr. Benson?
And if hearsay allegations, someone's not here. This all happened in the last 48 hours, 72 hours.
Two things is not here, but if I look at what's in here, first of all, you're mixing two things. Because certainly they can proceed by hearsay as regards to bond violation. So that maybe we can clear that part up, because so they don't need her here for that. Stated to the court that they can proceed without her if necessary, but that they also do know where she is.
I don't know how they could possibly proceed when there is not a
That's
stitch.
not your issue. They've made the representation to the court.
Okay, and I'm making a representation to the court that when you read the police report, which you have,
I read it.
then you know that there is only her allegation. At least for what I have in front of me and what you have in front of you. And he is here. He's availed himself to the court every time that I've had anything to do with him.
Why didn't he turn himself in between the time I revoked his bond to court? Should have instructed your client to do that the court had revoked his bond. So I want an answer to that question.
Yeah, I mean, we were going to be here today.
That's not an answer to my question. Mr. Allen.
According to what the defendant just told his attorney is that, he told him to just show up today and not turn himself in.
That's correct, Your Honor. I mean, and that if.
Oh, put me in handcuffs, man.
That's a wrong answer.
I'm
Way the wrong answer.
sorry, man. I'm asking.
I'll deal with this in a minute because right now I'm furious, Mr. Vincent, that you would represent that client. Defendant's remanded. Take him. Court's gonna stand in recess. Court calls the case of the people versus Cameron Carter. Recall.
It looks like we have to control.
Now, Vincent, on behalf of the defendant. Yeah, there was absolutely a mix-up. And as much as my understanding was that he had spoken to the court and they did not tell him to come in, and I should have come in. Yeah, it's absolutely a mistake on my part.
Well, it's not only a mistake, it's a sanctionable offense. And I think you ought to know that. To willfully tell a client or even to intimate to a client that they should in some way disobey a court.
In no way, shape, or form, Your Honor, did I meant to have that effect happen. My understanding was that he had seen you in person this week and that you come to court from. I would never, and I think you know that about me, I would never have anyone try to knowingly or disobey an order. I would never knowingly disobey any of your bond conditions or orders. He is, I mean, I don't know, Your Honor, this is a horrible mistake and I'll fall on my sword for it, but it is a misunderstanding. It's not any, in no way, shape, or form was I trying to get him to avoid justice, and he certainly is trying to avoid justice on this, Your Honor. I understand that these charges and allegations are serious. I mean, all I can say, Your Honor, is that my understanding was that he had spoken to the court this week and that he was free to come here Friday. We clearly had, at no point did I ever advise Mr. Carter to do anything else other than follow the law. And must have told him that a dozen times, something that every time I've talked to him, do not violate your bond, don't violate your bond, show up Friday. That's when we have a court date. My understanding was that was the understanding. And it is absolutely a snafu on my part, and I beg the court's forgiveness. He has an appointment today at 2 p.m. to see Washington Community College counselor. He's trying to get his CDL so he can take care of his kids. He is working at another job. He's availed himself to court today, Your Honor. If this is bound over to jury selection, he'll be there then too. He understands this is serious, Your Honor. He's just vehement in his innocence, and I perhaps have been overzealous on my part. I meant no disrespect to you, the court, to the people.
What I'm going to do in this case, because, I mean, something's got to be decided as to what was told this defendant. That may have to be resolved some other way, but the court will take whatever action it deems necessary, and I won't do that until June 26th, if I deem it appropriate to do so, because as angry as I am right now, I'm not going to make that decision on that. I will set a bond hearing in person in this case for June 26, 2023 at 9 a.m. All of the paperwork will be sent over, and we can deal with it at that point. In the interim, defendant's bond is revoked. I will adjourn the jury final settlement conference that we were going to have today, as well as the jury selection. Jury final settlement will be my next one, August 11th, 2023 at 9 a.m. Jury selection, August 14th, 2023 at 8:30. Defendant's remanded.
What begins as a routine court appearance quickly turns into a tense and emotionally charged courtroom confrontation when a serious question arises, not just about the defendant's charges, but about whether a direct order from the court was ignored. At the center of the case is a man facing disturbing allegations, including domestic violence and child abuse. These are not minor accusations, and the court is already aware of the defendant's prior legal troubles. The stakes are high from the very start, but the real tension begins when the judge addresses something that happened before this hearing even took place. Previously, the court had issued a clear ruling. The defendant's bond was revoked, and he was expected to turn himself in. That order should have resulted in the defendant surrendering to custody immediately. Instead, days later, he appears in court still free, not in custody, and that single detail instantly changes the tone of the entire proceeding. The judge, visibly concerned, begins questioning how this could have happened. A revoked bond is not a suggestion. It's a direct instruction, and failing to follow it can be seen as a serious violation. The courtroom grows quiet as attention turns to the defense attorney, who now must explain why his client never surrendered. The attorney stands and calmly insists there has been a misunderstanding. He explains that he interpreted the court's prior statement differently. According to him, he believed his client was simply required to appear at the next scheduled court date, not immediately turn himself in. He presents this explanation confidently, framing it as an honest miscommunication rather than intentional defiance. But the judge does not appear convinced. From the bench, the judge stresses that the order was straightforward and unmistakable. Revoking bond means the defendant is no longer permitted to remain free. It means custody is required. The idea that such an order could be misunderstood raises serious concerns, not only about the defendant's compliance but also about the attorney's judgment. As the judge presses further, the defense attorney maintains his position. He argues that there was no deliberate attempt to disobey the court. He emphasizes that his client showed up as instructed for the hearing, suggesting this demonstrates good faith rather than avoidance. Still, the explanation does little to ease the growing frustration in the courtroom. The prosecutor then rises to respond, and her tone is firm and focused. She argues that this situation is not simply about confusion over wording. She reminds the court that the defendant is facing multiple serious charges and has an ongoing legal history that makes compliance especially important. In her view, the failure to surrender is not a harmless mistake, it's a risk to the victim and to public safety. She explains that the alleged victim is not present in court, and there is a powerful reason why. According to the prosecution, the victim fears for her life. She has reportedly been relocated to protect her safety. This information shifts the emotional weight of the hearing. The absence of the victim is no longer seen as a weakness in the case, but rather as evidence of how serious and frightening the situation may be. The defense attorney pushes back strongly. He argues that fear alone does not prove wrongdoing. He points out that, at this stage, there has been no physical evidence presented in court, no third-party witnesses offering testimony, and no direct statement from the alleged victim during the hearing. He suggests that the case relies heavily on claims rather than verifiable proof. He also questions specific details in the police report, highlighting what he sees as inconsistencies. At one point, he mentions that certain phone numbers listed in the report do not belong to his client, implying that parts of the investigation may be flawed or inaccurate. His goal is clear: introduce enough doubt to persuade the judge that the situation should not lead to immediate detention. The prosecutor responds by clarifying an important legal point. This is not the trial itself. This hearing is about bond and compliance, not final guilt or innocence. The standard here is lower than beyond a reasonable doubt. The court only needs sufficient reason to believe the defendant violated conditions or poses a risk. She emphasizes that bond hearings exist specifically to protect victims and ensure defendants follow court orders. As the arguments continue, the judge's frustration becomes more visible. He repeats that the primary issue before the court is not the full criminal case, but the failure to follow a direct order. The judge notes that if attorneys or defendants begin treating court instructions as optional or open to interpretation, the entire system's authority is weakened. The courtroom atmosphere grows increasingly tense as the judge questions the defense attorney more directly. He asks whether the attorney truly believed that a revoked bond did not require surrender. The implication is serious. Advising a client incorrectly in such a situation could be considered professional misconduct. The defense attorney insists again that there was no intentional wrongdoing. He emphasizes that he acted based on his interpretation at the time and that there was no effort to deceive the court or help his client avoid custody. He frames the situation as an unfortunate mistake rather than a deliberate strategy. But the judge raises the possibility that this could be considered a sanctionable offense. He explains that willfully disregarding a court order, or advising a client in a way that leads to ignoring one, is not a minor issue. Such actions can carry consequences beyond the single case, potentially affecting the attorney professionally. For several moments, the discussion shifts away from the defendant and focuses almost entirely on the attorney's responsibility. The judge questions whether proper steps were taken to clarify the order. He suggests that if there had been any doubt, the attorney could have contacted the court or requested clarification rather than allowing the client to remain free. The prosecutor supports this concern, emphasizing that the justice system depends on clear compliance. She reiterates that the defendant's history and the seriousness of the allegations make strict adherence to court instructions especially important. The defense attorney, now under significant pressure, continues to defend his actions. He argues that nothing about his conduct was sneaky or intentional. He maintains that his client's appearance in court demonstrates cooperation rather than avoidance. He also suggests that punishing the defendant or attorney for a misunderstanding would be unfair. Despite this, the judge signals that the matter cannot simply be overlooked. The seriousness of the charges, combined with the failure to surrender, leaves the court with limited options. After a long intense exchange, the judge finally delivers his ruling on the immediate issue. He announces that the defendant's bond will remain revoked, meaning the defendant will be taken into custody. The decision reinforces the authority of the prior order and makes clear that compliance with court instructions is not optional. The judge then addresses the broader procedural schedule. The planned jury settlement conference and jury selection will be postponed to a later date. He explains that additional time is needed, not only for the case itself but also for him to consider whether further action should be taken regarding the attorney's conduct. This statement leaves a noticeable weight hanging in the courtroom. While the defendant's custody status has been decided, the possibility of professional consequences for the attorney remains unresolved. As the hearing concludes, the tension slowly fades, but the underlying questions remain. Was this truly an innocent misunderstanding? Or was it a risky legal maneuver that backfired under judicial scrutiny? The court does not answer that question immediately, leaving the outcome open for future determination. What is clear, however, is that the hearing serves as a powerful reminder of how critical clear communication and strict compliance are within the legal system. A single interpretation of a court order, whether mistaken or deliberate, can shift the direction of an entire case, affect personal freedom, and even put a legal career under examination. And in this courtroom, what started as a procedural matter ultimately turned into a dramatic clash over authority, responsibility, and the consequences of ignoring the words of a judge.